The most common mistake that I've seen businesses make with respect to their agreements that have gotten them into a situation where they're spending a lot more money down the road on legal, fighting it out in litigation, is not having a well-structured operating agreement in place. I've seen countless times that a form is used online, that the operating agreement is a second thought, that some attorney may have drafted it, but the client didn't really work with the attorney. They may have gone cheap on it, which if you go cheap, the attorney's not going to spend much time on it. So in the very beginning, when this partnership of sorts, this combination of owners is formed, these owners aren't taking the time to think about all the all-ifs. What happens if, for some reason, one of the partners steals from the company? Is there even a clause in there that allows this member of the company to be terminated for cause, to be removed, their membership interest gone? If there's nothing like that, you're kind of stuck in that situation. You're stuck going to court. You're stuck maybe dissolving the company altogether. It doesn't cost much, but it does cost. And clients should be willing to spend that kind of money up front to put those things together appropriately. Now, I'm going to build off of operating agreements because different kinds of operating agreements are appropriate in different circumstances. When you start getting into outside investment, anyone putting money into the company in exchange for an ownership interest, you're also implicating the securities laws. I've seen so often real estate investors call a deal a syndication just because there's an operating agreement. That's really the only document in there. There's no private placement memorandum. There's none of that because look, going to a securities attorney, getting all the proper documentation and disclosure documents in order may cost $20,000, $30,000 and they don't want to do it, right? They want to bootstrap this thing and just put it together. Maybe they go to a real estate attorney that really doesn't know much about the securities laws. So what I see in that situation could be really, really bad. That involves a potential SEC enforcement action, which we handle those as well. And those can get really expensive because you have one or more three-letter agencies really digging into the documents of the client, requiring testimony of the client. There's civil penalties, there's criminal penalties, and having the entity formed doesn't protect these people because they can go after the individual for fraud, for securities fraud. That would all be encompassed within this operating agreement, these core documents. There would be disclosures and it would define the interest and all that. Can't tell you how often I've seen that, and it is way more expensive to deal with it after the fact. Instead of spending $5,000 up front, it could be spending $50,000 later, and it could be being stuck in a contentious battle for a year or more.